Welcome to the Moran Center training on aiding and advocating in landlord-tenant disputes. My name is Megan McClung, and I am the Moran Center school-based civil legal clinic attorney. The Moran Center historically represents youth and young adults in criminal and educational proceedings. And the Moran Center started the school-based civil legal clinic in April 2018. The clinic was started in an effort to meet more of the legal needs of families with school-age children, to address major issues of health and safety that were the concerns in their students' lives. And this clinic supports families and children that attend specifically Evanston Skokie District 65 schools. The clinic provides free legal assistance and advice on civil matters, such as family law and unemployment benefits, which will be the subject of the next two trainings. And today, the focus is on evictions, one of the most common issues presented at our clinic. A house is made of bricks and dreams, and a home is a place of love, hope, and dreams. 1 in 4 families present with a housing-related issue when they come to our clinic. Questions that they bring are, how can a family compel their landlord to make necessary repairs to their home? What can their family do if they're unable to pay rent? Or how long can they stay in their home? Questions like these are the issues that we tackle on behalf of families and that our volunteers help with at the clinic. And it's important to note that our clinic right now is working remotely, doing case intakes and handling court calls via Zoom and phone calls. Our goal here at the clinic is to address families' housing issues because it impacts a child's ability to stay in and succeed in our schools. A child's health really starts with having a safe and secure home, and more so now than any other time because of COVID-19 hardships. The role of volunteers and the goals of this training, we're going to review tips and techniques that you can give to tenants to prevent landlords from filing evictions in the first place, and how you can give clients advice on navigating landlord-tenant disputes through a basic understanding of landlord-tenant laws and also the eviction process. We'll also briefly cover COVID-19 and its current impact on evictions, which could take a whole nother hour, but we'll briefly go through it today. Many landlords, and this is the truth, this is the secret to tell your client, is they don't want to file an eviction in the first place. Landlords just want to be paid. And to file an eviction, they have to pay filing fees to the court, a few $100s. And they have to pay their attorney's fees, a few $1,000s. And maybe even their tenant's attorney's fees if they lose. And they have to go to court or to an attorney's office that takes their time. And in the end, what they have is an empty apartment that they have to rent to somebody else. So really, this is information that our volunteers use and can empower their clients to negotiate agreements with the landlord to pay past due rent for a lesser amount or even for a longer time. And it's also important to know that 99% of the cases that come to our clinic are tenants. We do have some landlords who come to the clinic, and this is helpful information as well. Because one of our goals is to prevent evictions, one of the things to do is empower your clients and let them know that they should contact their landlord and try to get an account balance. How much do they owe? Get the account ledger. A lot of times that shows unpaid costs and fees for paying rent late, and those can be easily negotiated. This also empowers the tenant to be able to stay where they're at while they're paying back the rent and avoid the late fees and possibly court costs and attorney's fees. Most importantly, it preserves the tenant's credit report rating, which is so important for when they should apply for housing in the future. And most important right here is that anything that they negotiate with the landlord for repayment of back due rent is that everything should be in writing. All of their communications with the landlord should be in writing and saved. So communicating with the landlord, just to emphasize it one more time, the tenant, the client, should try to keep copies of any emails, letters, or texts, and they should document any request for repairs by the landlord. For any time they're going to pay rent, they should avoid cash payments without receipts, and demand receipts or send in a money order or check, or send in the money electronically so that they can keep a record of payments. When negotiating or empowering a tenant to come up with a repayment agreement with their landlord, the agreement must be in writing. And Illinois law allows a landlord to take partial payment of rent and still file an eviction unless the landlord has agreed in writing to delay the eviction. So that's why it's important to get the agreement in writing and that they will not file an eviction. And the agreement can be simple. There's some posted on Illinois Legal Aid online. And the Moran Center also has templates you can use. And here is a sample. For our volunteers on the right, we provide instructions that they can use when helping a tenant put together a payment plan with their landlord. And on the left is a sample repayment plan. Something to note, and this is always a question, is should the attorney get involved right now? Like, should us, the volunteer pro bono attorney, get involved? And the answer is it depends. A lot of times, the best thing to do is empower the tenant to advocate by themselves. Because sometimes when attorneys get involved, it escalates and landlords aren't as willing to negotiate. And so, generally speaking, it is better to assist with the paperwork and encourage the tenant to try and come up with the payment plan with their landlord, and letting them know all those reasons why they should be able to get a reduced amount or late fees waived, because evictions cost money and the landlord really wants to keep them in the unit. And also that they should have more time to pay past due rent, especially during this COVID hardship. Emergency rental funds are available. There's been some this past month made available federally and locally. And generally, even before COVID, tenants could access emergency rental funds by calling Evanston's 311. And it seems like common sense, but it's really important to tell the tenant, the client, that they can use these emergency rent funds as part of the repayment agreement with the landlord. Repayment, housing, and subsidy. It's important to note here that from time to time we have tenants who are either housing vouchers or they're in subsidized housing. And if that's the case, then you should talk to them about interim recertification. Without going into it much further, it's kind of tricky, but every year they are required to recertify. And right now, because of COVID, the housing provider is accepting interim recertifications, which usually can be submitted if there's a change in income. And right now is almost always being done because of COVID and the impact on people's employment. And so if they can submit an interim recertification showing that their income has gone down, then their portion that they're responsible for rent can go down as well. It's just another way to empower tenants and help them with the repayment plan. Now that we've talked about empowering tenants, trying to avoid evictions because one of the #1 issues is non-payment of rent, now we'll go over some of the fundamental landlord-tenant laws that impact the cases we typically see at the clinic. There are many more than what are listed here. There's the Cook County Prohibition on Discriminatory Practice Ordinance. There are also Code of Federal Regulations that cover subsidized housing, but those we would need to have a whole nother seminar on. But just to get a good handle on some of the issues that present to our clinic, we'll just go over some of the federal, one of the Illinois laws, and then mostly over the local Evanston Residential Landlord and Tenant Ordinance, because that is typically what applies to the issues that we see at the clinic. The Violence Against Women Act, known as VAWA, it's a federal law. What's important to know about this is if we see a client and they've been a victim of domestic violence, it protects them, and it protects them from being evicted. There's a similar law that is called the Safe Homes Act in Illinois, and this provides even stronger protections, and it allows somebody who's been a victim of sexual violence or assault, or even if they can show a credible imminent threat of sexual assault or violence, they can notify the landlord 3 days before or 3 days after moving out. And it means that they can terminate their lease and not be responsible for paying any further rent. There's also, now going into the Evanston's Residential Landlord-Tenant Ordinance. What's really important to know is that Chicago has an RLTO as well, and it's very similar to Evanston's. But Evanston's has certain differences that I will note here that protect tenants. And the RLTO, it's more comprehensive than the local state laws, and that it provides a comprehensive ordinance governing the rights and responsibilities of tenants and landlords. And it covers the tenant's rights to repair, a landlord's obligation to keep a habitable premise for their tenants. It covers retaliation protections for tenants and protections for tenants against landlord's unlawful entry, and many more protections. The RLTO and the Evanston Building Code, it still applies during COVID-19. And it's important to note that when we get towards the end of this presentation, when we go over some of the new laws because of COVID-19 and how they affect evictions and tenancies. So talking more about the Evanston Landlord-Tenant Ordinance, one of the common problems is maintenance problems. For example, a client presented and had a leaking roof. It leaked on her bed. It caused her to have to get another bed. Her place smells of mold, and it's just not a very good place for her children or for her. And so before she even presented to the clinic, what she decided to do was to withhold a full month's rent. And then the next month she paid and continued to pay. And she reported to the landlord and recorded it that her roof was damaged and leaking. And the landlord said they would come and look at it. And then they never did, and they never fixed it. Instead, the landlord proceeded to file an eviction against her. And I'll get into more about how we handled that eviction case. But if she had presented to us before deciding to just withhold 1 month of rent, we could have helped prevent that eviction by talking to her about what remedies she has under the Evanston RLTO. And so we could have advised her that she could send a letter to the landlord demanding that the leaky roof be repaired within 14 days. And then if the landlord doesn't repair it within 14 days, then she could make the repairs and deduct up to $200 or 1/2 of the monthly rent, whichever is greater, from her next month's rent. And she could do it the next month rent and the next month rent until she was fully paid back for the cost of the repair. She could also call the city of Evanston and report a building code violation, have the inspectors come out and inspect. And if they inspect and cite the landlord for a building code violation, she could also withhold a reasonable amount of the rent for the reduced value of the premises. And just as a rule of thumb, I've generally told tenants to not withhold more than 1/2 of rent for failure to repair where there's been a building code citation. And then another thing she could do is she could break the lease. She could give the landlord a 30-day notice saying that her place, her home where her kids are, is uninhabitable because of the leaking roof, and that she wants to move out in 30 days. And so long as she gives that 30-day notice, then she could break the lease. On this next page is an example, and it's something that I can share with our volunteers of a 14-day demand letter that in the case that I provided, she could have provided to her landlord. And so again, we want to empower our clients to talk to their landlords before an attorney gets involved, because that can just escalate the problem. And so we would walk her through how to fill this out, how to put the landlord's name on it, to list the repairs needed, and to list, if there's anything else besides the leaking roof, to include that. The request that it be done in 14 days, and also letting the tenant know that the clock starts to tick after the landlord receives this. So if she wants that 14-day to start sooner rather than later, hand delivering it is a very good option. Mailing it means you have to kind of put in 3, maybe 5 days until the 14-day clock ticks. But it is something to advise the client on. But in the interim, I would have told the client to start to call companies and get at least 3 bids for the repair, so she could know what it will cost to do so, because that could take a good 14 days anyhow. So just some good advice, some good common sense advice to share with a client who at that point, when they present, they are distraught. They are needing somebody to help them see around the corner that there is a way to repair their home so that they can go back to keeping their home safe and the place where they had their hopes and dreams of their children. Another issue that we do see, unfortunately, are bed bugs. We've had clients who move in and then report that they suddenly have bed bugs. Unless there's any proof that the bed bugs were brought with them, it is absolutely the landlord's responsibility to take care of them. And also any type of insect, rodent, or other infestation. Any type there is such an infestation, you should also tell them to call 311 and report the bed bugs. Unlawful entry. The landlord, the Evanston RLTO protects tenants' privacy in their homes by saying that landlords can't enter their home unless it's for a legitimate purpose, and giving 2 days notice. It doesn't specify whether it has to be written or verbal, but they have to give 2 days notice, except for emergencies. And that entry has to be asked for during reasonable hours. I've seen clients appear at our clinic where they have a landlord who lives on site. That's pretty typical. And they come knocking on their door at all times and without any notice and ask to enter. And if this happens repeatedly, I've suggested to them to write down those dates and times. And if any further entries are requested by the landlord, to note those dates and times. Because if we can show repeated entries by the landlord that are unreasonable at unreasonable hours, or it's not for legitimate purposes, then it could arise to harassment and constitute a violation. And then we go back to what could be remedies for the tenant, which would include terminating the lease and moving out if they give a proper 30-day notice. It could also include going to court and getting an injunctive relief, stopping the landlord from continuing to harass them and asking to enter without proper notice, and possibly 1 month's rent or twice whatever damages they've suffered, whichever is greater. And lockouts. Unfortunately, because of COVID-19, we're seeing more and more lockouts. When we talk more about the eviction moratoriums because of COVID, there are landlords who are resorting to self-help, and that includes lockouts of their tenants. Lockouts are illegal. And what is a lockout? Well, it's when a landlord changes the tenant's locks. They plug the locks, they remove the doors, they remove windows, they remove tenants' property. They do anything to make the apartment or their home uninhabitable. And the bottom line is lockouts are illegal in Evanston. Even if they have an order of possession, a landlord cannot resort to self-help and lock out a tenant. The only way a tenant can be physically removed from the property is by the sheriff. And we'll talk more about how there's a halt on that because of COVID. It's also important to know that an intentional utility shut-off by a landlord is a lockout. I've seen a case where it was a 2-flat and the landlord took over the utilities and put them back in their name and then stopped paying for them. That constitutes a lockout. And again, we can go back to the tenant remedies by filing in court for injunctive relief and possibly getting damages. What's the best advice to give, the most immediate relief, is that the tenant should contact the local police department as soon as possible. And just to share some of my experience, Evanston police officers, when they are called to a situation where a tenant has been locked out, they do ask to see if there is an order of possession, and this is pre-COVID. Even if there's an order of possession, the police will say that that they cannot be locked out. It's only the sheriff that can properly enforce it. Security deposits is another issue that we see, where if one of our families is moving, after they move, they have a right to the return of their security deposit in full, unless the landlord provides a written itemization of what damages were in the home, and they list those damages, what they paid to repair them, and they provide that to the tenant within 21 days of their move out. Any amount that they didn't pay towards the damages, they have to give to the tenant, including the security deposit interest, which is regulated by the Evanston RLTO. It's really important to know that damages is not the same as wear and tear. This is where landlords will routinely try and deduct for some things like carpet cleaning or painting walls when there's really not damage. And normal wear and tear doesn't constitute damage, so that is something to look for. And if the landlord refuses to produce an itemized list, then the first step is to send the landlord a letter demanding the return of the security deposit. And once again, we have samples that I can provide. The RLTO protects tenants from landlord retaliation. It's unlawful for a landlord to retaliate against a tenant because the tenant complained about bad conditions. For example, my client who complained to the landlord about the leaking roof. It's also unlawful to retaliate against a tenant if they exercise their right, such as reporting the leaking roof to the city of Evanston, and that it's a building code violation. Other conduct that's prohibited is that they can't retaliate by terminating the tenancy, increasing the rent, decreasing services, threatening to evict or actually filing the eviction case, or refusing to renew the lease. In the case where our client reported the leaking roof and had withheld the rent and not in a way that's supported by the RLTO, we were still able to defend her in the action, because when the landlord did file the eviction case, we were able to show that it had amounted to retaliatory eviction. And the retaliatory eviction is important because landlord conduct that happens within 1 year of a tenant complaining gives them a defense in the eviction matter. And it also means that they could try and get damages of up to 2 times the monthly rent. And so in the case where we represented the mom who reported the leaking roof, we were successful in getting the eviction complaint dismissed and having a payment plan for the 1 month's rent that she missed. And it ended up being a pretty successful result because we're able to file the retaliatory eviction portion to it. Do we have any questions so far?
Yes, we do. We have one question, Megan, from, I hope I'm saying your name right, John Strauss. He asks, what happens when the landlord fails to pay building utilities and tenants lose utilities? Can that be considered a lockout?
Yes, that can be considered a lockout. And without going much deeper into the details, there are other laws that regulate utilities and in regards to not being able to pay them. But yes, if a landlord is responsible for paying the utilities and doesn't, that's a lockout. Or if the landlord takes over the utilities, like in the example I gave, that would constitute a lockout as well. And the first thing to do is advise them to call the police. And then the second thing is that we could look into filing an action in court, an emergency petition for injunctive relief to get the landlord to turn the utilities back on, as well as seek damages. For example, if their refrigerator was out for a day or two and they lost all that food, that's the damages that we can show and try and help put them back in as good or better position than before it happened. Are there any other questions?
There are no other questions at the, oh wait, we just had one that came in from Richard Horton, who asks, how often is mediation used as a means to negotiate a repayment agreement? Do you think it's a useful tool?
Really good question. Mediation is an excellent way to help a landlord and a tenant come up with their repayment plan. The City of Evanston, as well as Connections for the Homeless, and also Open Communities, those are 3 organizations in Evanston that could possibly help facilitate the mediation. I would recommend that a volunteer attorney not get involved with the mediation, because if they don't come up with an agreement, then we are prohibited from representing the tenant if there's an eviction action filed. And so that's why we really want to empower the tenant to self-advocate, also give them places that they can call and maybe have somebody help mediate. There's also the Center for Conflict Resolution in Chicago that may be able to help, and as well as other resources. And so mediation is definitely a good option. Thanks. Any other questions?
I'm not seeing any at the moment.
Okay, keep the questions coming. It really helps. And questions, there's never a bad one, because while it seems like landlord-tenant issues are common, they do tend to get complicated, Each one is different from the next. And remember, what we're going through now is just to get a basic understanding of what tenants' rights are, since that is 99% of the cases that we see are tenant related, so that we can properly advise them, maybe even represent them if it gets to the point that they're in an eviction action, or in some cases refer them like to mediation. So in order to help manage clients' expectations, it's really important to know the eviction process. It's unfortunate when a client comes to the clinic and they've already received a summons to court for an eviction action. And the first thing that I always talk about with the client is to let them know that they have time. This doesn't mean they have to get out this week. And I'll go over that in more detail a little bit later. But we're going to start from the beginning of what the eviction process is here, and really focusing on what's required of state and local laws, so that we can issue spot when we are doing a case intake, and so that we can inspire volunteers to take a case. Because as an attorney, one of the glorious things that we can do is represent somebody in court. And eviction trials are short in nature, and they happen. And so if you can kind of get an understanding of this eviction process, not only can you advise the clients, but you could also take on a case and navigate it, possibly getting it dismissed for finding technicalities, whether it's before trial or at trial. So we're going to go through the termination process, the eviction complaint, the service of summons, the court proceeding, and the eviction order. The termination process in Evanston provides greater rights than the Chicago residential landlord-tenant ordinance. And this is where there's a big difference. In Evanston, for the most common issue, which is non-payment of rent, the landlord has to provide a 10-day notice. In Chicago, on the other hand, it's only 5 days. So we've had cases where somebody presents with a landlord's 5-day notice because they used a template that's given to Chicago landlords. And if you see a 5-day notice, it's improper, and it can serve as a basis for a motion to dismiss. So looking at the termination notice, which is the first step in an eviction proceeding, can greatly help the tenant. So a 10-day notice is required for non-payment of rent. It's also required for breach of a lease provision. A 30-day notice is required from a landlord if they are choosing to not renew a lease that has expired. And a 90-day notice is required for foreclosure-related evictions. At the bottom here, the service of the notice is another technicality, and it's governed by Illinois law. And this is a way that we've been successful in getting cases dismissed. I note this because it's something to look for in a case intake. And so when you ask them what kind of termination of notice did they get from the landlord, also ask them, how did they get that notice? Was it personally? Did somebody hand it to them? Did they get it by certified mail, which means they had to go to the post office and retrieve it? Or the post man or woman provided it to them? Or was it posted on their door? These are the 3 ways that a tenant must be served in Illinois. And if it's not done by one of these 3 ways, then the termination process, the notice process, was not proper, and it can serve again as a basis of a motion to dismiss. Just as a side note, even if you win on one of these technicalities on a motion to dismiss, the landlord can still refile after they've served and the proper notice and gone through that channel a second time. The eviction complaint. On the right is just a sample of an eviction complaint. It's very basic. You can see in number 2 that all they have to do is allege that the defendant failed to pay rent, the tenant held over after the tenancy ended, or they breached the terms of the lease and they put that in. And now there's a new Supreme Court Rule 139 that came out this summer, and it requires landlords to include on the eviction complaint an attachment, which is a copy of the termination notice and where it applies, the relevant portions of the lease that they breached. Again, this is new. Keep a lookout for this because a lot of landlords will probably not comply with this in the beginning. Is there a question?
Yes, there is a question from Nicole. Nicole asks, for service of notice, does Evanston law allow the lease to specify that it is okay to serve alternate ways?
That's a really good question. And to my knowledge, that answer is no. So if we go back, they can serve it by posting. And posting means that they literally put it on the door. But they can only post it on the door if they're not in possession. And Nicole, that's a good question. I don't think that there's any other ways that it's allowed. And in fact, I've argued in court that the Illinois statute is what has to be followed by landlords. There's Supreme Court cases that control on that. I'm currently in a heated motion to reconsider case because a landlord claims that their first-class mail was enough because the Code of Federal Regulations allow that in subsidized housing. But our argument is that it's not allowed because Illinois law provides a greater protection for tenants and that it has to be personal service of the termination notice or by certified mail or posting when they're not in possession. Are there any other questions?
Yes, as a follow-up to that, so no provision, or John asks, so no provision for electronic delivery email.
At this time, that is my understanding. If it's something I'm writing down, and I'm going to double check on that because with COVID, there has been, it's kind of like playing soccer and somebody keeps moving the goals, and there could be a recent change, but I don't think electronic service is sufficient for the termination notice. And one caveat to that, if there was service by an email and then the tenant recognized that and said, yes, I received it, then they might have waived the ability to argue they didn't get proper service. So just another thing to note. It gets tricky. So moving on from the eviction complaint, and again, there's this new Supreme Court Rule 139. Look to see if there's attachments about the termination notice because it will show whether they served it properly and what was the breach of the lease. So service of the summons. This is different than the termination notice that's required before filing an eviction action. This service of summons tells the tenant when and where they need to be for the first court date. When tenants have approached our clinic, this has been what they have in their hand. It's really important to note what the court date is. Had they missed the court date, is the court date coming up? The summons, if they have it in their hand, it usually means they've been served with it properly, but I would still ask those questions. How were they served? Did somebody hand it to them? Was it posted on their door, which is improper? Because posting of a summons is different from posting of a termination notice. Posting actually occurs by posting it at the courthouse. And then just to generally advise clients to always check their mail, to never ignore any mailed notice that look like court papers. As soon as they get them, to call again. the court proceeding. So if your client's already in a court proceeding, or perhaps you decide that maybe you will take on one of these cases, here's some ways to start to unpeel and dive into the court proceeding. So the first court date is usually a status date, and at that time, the judge should provide time to do discovery and set it over for another trial date. Actions move pretty quickly in eviction court. It's pretty typical after the first court date for something to be set for trial within 30, no longer than 60 days. And possible defenses to look at, if you decide to help represent in a court proceeding, is, was there retaliation? And we talked about that earlier. Was there improper notice of the termination or the process of serving the summons? Was there any discrimination and denying reasonable accommodations to the tenant who might have disabilities? Because there's laws that govern that. So there's lots of things here to consider, and I'll just give an example of this last one. So a client presented who had a dishwasher that she was hooking up to her sink and using it. And the landlord said, the lease says you cannot have dishwashers or washers or dryers in your unit. And she said, but I have a disability. And she had a documented disability where she couldn't bend over and had back issues. And with that, we were able to bring it to the landlord's attention that allowing this dishwasher was necessary for her to accommodate her disability. And so that just took some letters. Again, it's something that I can provide volunteers with. And in the case I'm talking to you about, that actually helped prevent an eviction because she received the 10-day notice, and then we were able to thwart that with our reply letter. But this could also serve as a defense to an eviction action. And then trial or settlement. You know, we could spend a few more hours on this, but the bottom line is if you get involved in a landlord-tenant action and represent one of the families, it can increase their chances of staying where they're at, of helping them find possible defenses, and most importantly, give them time. When an attorney gets in a case, it almost always doubles the amount of time they have in their action, final action by the court versus if they were alone. So let's say you represent them and there is an eviction order entered, or a tenant comes to our clinic and there's already an order entered against them, which does happen. So if a judge or jury determines that the tenant should be evicted for the reasons stated in the complaint, then the judge will enter an order of possession. And that order of possession is typically stayed by the judge for 14 days. And it's important to know that that order of possession can only be enforced by the sheriff. Again, that takes us back to lockouts. If the landlord tries to go back to self-help remedies and do a lockout, the tenant should call the police. Another thing to help tenants with is helping them check the Cook County's website for the status on the eviction. If an order of possession is entered, and let me take a step back, this is pre-COVID right now that I'm talking about. This is what typically happened pre-COVID. If there was an order of possession, you could check the tenant's website. The sheriff will assign a case number, and you could check the website on a weekly basis to see when the tenant case would be up for the sheriff to enforce. Pre-COVID, sheriff could be behind weeks, sometimes months. Right now, with COVID, the sheriff is prohibited from enforcing orders of possession, whether they were entered before or after COVID. And whenever that is lifted, it is my guess, as well as anybody's, how long sheriffs will be able to enforce all of the orders of possession. So this is going to get sticky and tricky as we move along. But what's important to know is that only the sheriff can enforce a tenant to move out of their property. Is there a question?
There is a question from Georgine. She asks, is there a protection for children where the landlord is alleging too many people living in the unit?
That's a really good question. And the answer is it depends. Landlords have the right to have who's going to live at the premises listed. And if there's too many tenants living there, that violates the occupancy number for that unit. And the landlord could get cited by the city. And so if there are too many children or even too many adults, that could be a violation of the lease. Now, again, because of the eviction moratorium, there's not much that could really be done at this point. But it's possible if it was so many people living there that it poses a health or safety threat, maybe the landlord could file something to enforce the proper amount of tenants living there for health and safety reasons. But otherwise, that really is something that you'll need to look at the lease and look at what that occupancy limit is for the tenancy. Any other questions?
None at the moment.
Okay. So I said I would get to this earlier. Typical timing of an eviction, the rainy day up there. And this is really pre-COVID. It's important to know the timing of an eviction because the first thing clients want to know is how much time do they have to stay in their home with their children. And it's so important to let them know that they have a lot of time, actually. In the end here, you'll see that they can expect, a minimum of 4 months, and this was pre-COVID. And if you go through this, and I'll just kind of go through it quickly, this is the logic behind why there's so much time. So a landlord has to file the termination notice, which could be a 10-day or 30-day. And then they can't file the eviction action if there's not compliance by the renter in paying the amount of rent owed or complying with the breach of lease. They can only file that after that 10-day or the 30 days expired. And then they have to file in court. That takes time to do and contact an attorney. And then at a minimum, the summons goes out and then there's a 30-day return date. And if the tenant gets served and does nothing, it'll go to court and it could proceed quickly, could proceed within 2 months, that the landlord gets an order of possession. But if the tenant does appear in court, like we talked about before, they could be entitled to at least one continuance, usually 30 days. If anything, if a tenant came to the clinic today, said, I have a court hearing tomorrow, and we don't know if we can get an attorney to represent them, tell them to go to that court hearing and tell them that they should ask the judge for time to secure an attorney. And that should give them 30 days to try and secure an attorney. And then that continues the matter. And then if the attorney comes in at that next date, that attorney might get another 30 days. And then they might be able to file defenses, counterclaims, motions to dismiss, which can provide even more time. And so in the end, right here we have, I've advised that they can expect a minimum of 4 months, and it could be much more, and especially much more because of COVID, which I'll get into in the next couple of slides. So now getting into this moving target, there have been moratorium on evictions issued by Governor Pritzker starting in April. The most current one was issued in August, and it is set to expire September 19th. And it says that landlords cannot file eviction matters unless what's happening poses a threat to the health and safety of other tenants. That's where that occupancy issues kind of slides into this gray area. Or if the violation poses immediate and severe risk to the property, or it's causing other building or health code violations. But non-payment of rent, that cannot arise at this point for a landlord to file an eviction proceeding. Now, can they file and serve the tenant with the 10-day notice for failure to pay rent? That's debatable, but most likely the answer is yes, they can still serve the tenant with that notice of termination, but they can't enforce it right now. And this executive order also prohibits the enforcement of eviction orders that were obtained before COVID. So if a landlord got an order of possession in February and the sheriff still hadn't enforced it when COVID hit, they still can't enforce that until these executive orders are lifted. There's also the recent, effective as of September 4th, the Federal Center for Disease Control, the CDC, moratorium on evictions. This is a halt on evictions because they want to prevent the further spread of COVID-19. They want people to stay at home, and by having evictions and people moving around, it thwarts that goal. And so this federal law says no evictions through December 31st, 2020. And this is really key to know. It's not a blanket moratorium. The Illinois one is much more strict. And there's right now efforts to try and get it extended again in Illinois. And the reason that I bring this up is that this federal CDC, it only applies in matters where there's non-payment of rent, and it only applies for qualifying renters. So if a client presents, we would have to talk to them and find out if they could self-advocate for themselves and certify with a sworn statement. There's a few things listed. Three of the most important is that they have to show that they're continuing to try to obtain housing, that they received a stimulus check or they have an income of no more than $99,000, and that they've had a loss of income because of COVID-19. And some of the other things they have to show is that they're trying to get rental assistance, but that was more readily available a few weeks ago than now. And so the bottom line for this, because this is a moving target, is that there are moratoriums on evictions. And it's important to just go through what is happening at this time, consult with me, and we will figure out what some defenses are at this point. And then it goes back to what can we do to prevent the eviction in the first place? Can we get the landlord to agree to a repayment plan because there's these moratoriums? Again, this is a reiteration that there is the governor's administrative order. There's also the Cook County Circuit Court has entered executive orders, administrative orders, both saying that the sheriff cannot enforce orders of possession and cannot evict tenants at this time. And again, it's a moving target, something that we have to look at a case-by-case basis as time permits. So now that we've kind of covered the basics, one of the things that we like to go through and help tenants with, because what the Moran Center is known for is expunging criminal records, and sealing an eviction record falls right into that category. And an eviction can be sealed. There is a statute on it. It's right here. And there are statutory requirements. and they have to be met. In fact, it means filing a motion on behalf of the client or empowering them if they're representing themselves with the information that they have to tell the judge to try and get their case sealed. And so just briefly, a case can be sealed if the case is sufficiently without a basis in fact of law. Should have been filed in the first place. In cases where I filed retaliatory eviction, where we've had motions to defend a matter because there's improper service, that can rise and meet this requirement. Other things that you have to show the judge is that it's in the interest of justice to seal the eviction case, and that it outweighs the public's interest. And so the way to show that is by arguing how the tenant's credit report will be severely impacted. It impacts them for at least 7 years when they try to apply for additional housing. And this second part about the public's interest, there's different ways that judges look at that. And judges have the discretion to seal cases. And practically, many judges will seal a case if a landlord doesn't object and if there's an agreement by the parties, except in Skokie, where the particular judge I've been before many times asks about 2 factors which aren't listed in the statute, but which he bases his rulings on. And he asks, how long has the tenant resided there? And has the tenant been evicted before? Because this particular judge has shared with everybody in the courtroom that he thinks tenants who are good tenants, meaning they've been there for a while, an eviction hasn't been filed against them previously, should be entitled to get their eviction case sealed. So again, case-by-case basis, it's based on the judge's discretion, and I can help provide sample motions to seal cases, and I can help volunteers walk through how they can do that on behalf of tenants. Is there a question?
There is a question. So I guess Georgine is asking, she said, ask for sealing as a part of any negotiated settlement. That's the question.
Yes, absolutely. Because when they don't object, it greatly helps in getting the judge to agree to use their discretion to seal a case. So absolutely, using that as part of a settlement in a eviction case is a good thing to do. And I'll note here that post-foreclosure eviction actions, and again, that's kind of a subject that we could spend a whole nother hour on with another training, those are automatically sealed. And what's really important to know is you have to get a sealing order from the judge and then physically give that to the clerk's office so that they will go onto their computer and wipe out the court case so that it's no longer viewable by the public. So if you are a new volunteer, we provide sample questions for intakes. And this is an example. It's part of our volunteer manual, and it lists sample questions that you can ask anybody if you're doing a case intake. And for our volunteers, there's a spectrum that you can volunteer to just do case intakes. You can volunteer to do case intakes and advise, and possibly represent. And these are questions that you would go through, such as, do you have a written lease, and how long have you lived there? How much was your rent? Why haven't you paid rent? Is it COVID related? Questions about the termination notice. Why are you being evicted? And so forth. Is there a question?
Yes, there is. Next question is at what point in the process does the eviction go on the tenant's credit report?
That is a good question. And unfortunately, the answer is when the eviction is filed. So when the eviction is filed, there are these agencies out there kind of like TransUnion, but these are smaller agencies that specialize in scrubbing the websites of circuit courts and seeing when eviction filings were filed, and then they report those to landlords who pay to know if there's an eviction case. So it's when there's an eviction case, that immediately affects their credit rating when it comes to being able to then apply for another housing unit. So here we're getting close to the end. We're going over a little bit of our time, but not too much. This slide really is the reminder for clients, and especially right now. While it is really difficult for a lot of our clients to pay rent, the moratoriums don't excuse clients from paying rent. In fact, they are responsible for the rent that was owed. And so that's really where we can help by helping to negotiate a lesser amount to pay or a whole lot more time, or helping them find rent payment assistance. And again, if there's an eviction notice, whether it's the beginning of the termination process or a summons, we can help the tenant self-advocate for protection under the CDC eviction moratorium, or if the Illinois eviction moratorium is extended. And the bottom line is to let clients know they have time. Evictions are a more lengthy process than they think. Most think they have to move out right away. But again, they have time, and we are here to help them with advice, representation, and referral when necessary. Any more questions? If you do, please put them in the chat box. I'll go ahead and answer them. I'll just note that there are more resources for our pro bono attorney advocates and even our clients that we help empower. They can also go to Illinois Legal Aid Online, where there's so many resources on landlord-tenant issues and sample forms. Is there a question?
There are none yet, but we want to give people
a
couple minutes to submit any questions that they have.
And so while we wait for any more questions, and you can always email me after this as well, I'd just like to share a quote from a book that I highly recommend. It's a reason why I'm so passionate about making sure that our families have safe, secure homes for their children. And it comes from the book Evicted, Poverty and Profit in the American City by the author Matthew Desmond. And in the book, there's this quote: "The home is the center of life. It is a refuge from the grind of work, the pressure of school, and the menace of the streets. We say that at home, we can be ourselves. At home, we remove our masks." And in today's world, we remove our COVID masks too. Again, I'm Megan McClung. I am the attorney that runs the school-based civil legal clinic at the Moran Center. Thank you for joining me for this training on how we can aid and advocate for our families in landlord-tenant disputes.
We have two questions that I think we can answer pretty quickly. Stacy asks, will you be posting an email in the deck that you used? And I think you may have said that toward the beginning, Megan, but.
Yes, I will email to everybody the slides and this information. We will also have this recorded and posted on our webpage for future volunteers to use as a resource.
Great. And then the last question is a more general question from Georgine. She says, she asks, how many landlord-tenant cases do you get each week?
Yeah, that ebbs and flows. And what I can say is that 25% of the matters that we handled this last year were housing related. And that we are getting a lot of the requests for assistance because a tenant has received a termination notice because of non-payment of rent due to inability to pay with COVID, and we're helping with those repayment agreements. But right now, because of the eviction moratorium, new cases have slowed down. And I'm part of a mass eviction defense project with several other legal advocates in Illinois, where we are sharing our resources. We are gathering and starting to get ready for what we're calling is this calm before the storm, when the eviction moratoriums are lifted and the landlords will be seeking evictions and the sheriff will be enforcing evictions. And so just to answer that question, right now, there's a slowdown in handling the eviction matters filed in court, but it is inevitably going to increase greatly once the eviction moratorium is lifted. And so if you can volunteer and help us, you will definitely be helping the families and the students of our community. Any other questions?
There are no other questions, but just a comment. Thank you so much for this excellent presentation, or thank you so much for this presentation. Excellent.
Wonderful. My pleasure, and thank you all for lending your time and talent. Have a good one. Bye.